Yes, hi everyone. Today's video I'm going to talk about insurance and reinsurance in the wake of the very important House of Lords decision, Lexington Insurance Company versus AGF in Insurance Company, Insurance Limited, I'm sorry, and Lexington Insurance Company versus Wasa International Insurance Company Limited. It's basically the Lexington Insurance Company is the appellant in this, is the respondent in this case, and AGF Insurance Limited and Wasa International Insurance Company Limited are the appellants reinsurers in this case. Lexington Insurance Company is the respondent insurer in this case. Basically, what does this case tell us? This case tells us that it's very important. It's a House of Lords case, and it was turnaround. It basically turned around the judgment of the Court of Appeal, stating that it's very important to for insurers and reinsurance to agree a common governing law for both contracts if they want to be considered back to back. And this is because if there is no incorporated or expressed within the terms of both contracts, the reinsurance contract and the insurance contract, a governing law, a choice of law, basically, a clause for which they would know in advance which jurisdiction is going to apply and how, therefore, it's going to interpret the terms of both contracts so that they could be considered back to back, and it's not going to be any shortfalls and different jurisdictions with regards to different jurisdictions applying to either reinsurance or insurance contract. That's creating unfair and prejudicial results to either reinsurance or insurance, and mostly insurers. It's that it's a very it's of crucial importance to safeguarding and covering this deficit, so that they are not met with any, let's say, unpleasant surprises in the form of not being covered by the reinsurance, basically. What happened in that case is, also, I would like to stress the importance of when there is no, at least when there is no insurance, when there is no governing law, a common governing law expressly agreed between insurers and the insurers and the reinsurers. There should be at least an express identifiable governing law over the contract of insurance, the insurance policy, so that the insurance policy is not at risk of being interpreted by differently from the reinsurance policy, which could basically potentially be interpreted by another law, as in the case that I just mentioned. The What happened was that the insurers had obtained reinsurance for a proportional premium for the proportional part of that premium, and they just found out that because they had not agreed, I mean, everything was more or less the same. The reinsurers had incorporated the same terms and the same length of coverage in from the contract of insurance into the reinsurance contract, and they had to find out. The insurance had to find out that the same law that applied to the insurance contract did not apply to the reinsurance contract, even though they were both the same. The Just because they had the same terms and etc., and the same premium, and it was factually, it was it was a question of fact. Basically, it was factually accepted that they were going to be interpreted in the same way, and therefore the reinsurers were going to cover part of the insured loss, the insured amount. The House of Lords said that just because the insurers did not cover themselves, did not agree, and they did not expressly make a point of reference to an identifiable governing law. It was their loss that they were determined by the Washington court to be falling within the interpretation application of the state of Pennsylvania. And how this affected the insurance company is that according to that law, according to the jurisdiction of basically Washington, it interpreted that the terms of the insurance contract, which were the policy, basically the coverage of the insurance policy, was extending beyond was basically extended beyond the 3 year period for which the insurance policy was purchased. Was that what that meant? And on the other hand, I just want you to have in mind that the reinsurance policy said more or less the same thing, exactly the same. Well, if we can't say exactly the same thing, but more or less, well, it's basically said the same thing, that it was going to cover a part of the proportional part of the insured amount for the 3 year time period for which the insurance policy was purchased. And the contract also said that the 3 year policy was going to apply to damage that was that started to loss, basically to loss that that manifested itself between that 3 year time period for which the insurance policy was purchased for. However, the court of Washington just came and said, because in the light of examining another 58 insurance policies with regards to amounts that were insured by other insurance policies, other insurance, the terms of the insurance policy were way too broad according to Washington law, and they covered 40 years, 40 years before the inception of the policy. That meant that the insurers had to basically cover for a period for which they had for a period that the damage had started, and the terms really did not contemplate that, because the damage the terms were basically, the terms of the insurance basically were stating that the damage and the loss that they were going to be covering for were was damage or loss that occurred throughout the 3 year policy, the 3 year time period of the insurance policy, since the insurance policy was purchased, if you want me to state it in a better way, and it was not agreed in any sense between the insurer and the insured that the insurer was going to cover damage since its inception, which apparently, according to that case, dated 40 years before the actual insurance policy was purchased. What that meant was when the insurance holders turned to the the reinsurance, the facultative reinsurance for indemnity. They claimed that the same law, the governing law of since they were back-to-back contracts, and it was facultative reinsurance, and they were supposed the terms were the same, incorporated from the insurance into the reinsurance contract. That since they were the same, they had to cover them. The reinsurance had to cover the insurers for the same amount. The amount that was excluded from the third year period brackets, and the amount that dated back to the inception of the damage that went 40 years before the actual policy was purchased. And the reinsurer said, they contested it, but the Court of Appeal said since they were back-to-back contracts, they were considered to be similar. They had to cover for part of that amount, proportional part of that amount. The case went all the way up to the House of Lords, and the House of Lords said no, the reinsurers don't have to cover for that amount because the by implication we have two ways of an application of a governing law. There is basically there are three ways. But there's basically one that's expressed to be agreed by two ways. I'm sorry, one that is expressly agreed between the parties, and therefore incorporated as a term in the contract, and another one is that one is by implication when there is no express agreement. And it was held by the House of Lords that since the reinsurance policies were brokered in England, therefore the by implication, since there was no express agreement of a choice of law, of a governing law between the reinsurance and the insurance, that the law of England and Wales was going to apply to the reinsurance contract. And it was tough luck that the insurers had no they had not made it they had not expressly made it clear in the contract that the law between the insured and the insurer was going to be the law of England and Wales, so that the insured knew. It was it was not the business of the court to know or to apply and be inside the minds and the heads of the reinsurers and insurers. It was none of its it was not of its concern, and therefore it could apply on that preliminary point between in the dispute between the insured and the Lexington Insurance Company, that the governing law was the law of Pennsylvania. That's what the Washington State said, and therefore gave a much more drastic, much more broad interpretation of those terms, which almost goes beyond logic. But that's what happened according to the merits of that case. That's a separate consideration. We're not going to expand on that during this video. However, we're going to say that it would have been unfair. The House of Lords said it was going to be unfair just because they hadn't covered for that, just because they hadn't expressly agreed that. They could have basically expressly agreed that, the reinsurers and the insurers, and that the law of whatever law was going to apply was going to be the law that was going to be covering their relationship. So therefore, they could have been held back to back, but it was beyond commercial logic that they were going to the insurers were going to burden the reinsurers with a decision of the Washington court, since that's not what the parties had reasonably contemplated, the reinsurers and the insurers. It was the law of England and Wales and that was going to apply. According to the law of England and Wales, the terms of the reinsurance that were incorporated from the insurance contract into the reinsurance policy stated that they were going to cover a proportional part of the 3-year time period for which the insurance policy was purchased. and they were going to cover damage or loss that was sustained by the insured since the purchase of the insurance policy. That's what the reinsurers were going to cover. Had things been differently, though, had they agreed the governing law, they would have perfectly been back-to-back contracts, but they had not done so, and therefore the courts could not transgress this point of law. They couldn't really make a travesty decision otherwise, as basically pointed and shown otherwise by the facts of the case, which was that the law of England and Wales applied, and it was really tough decision on the insurers, which in the end were not covered because they were not covered adequately, because let's say the Washington court seized the chance to make its own interpretation of the terms by taking advantage of the fact that the insurers had not make it clear and explicit that the governing law was the law of England and Wales, and therefore that the insurance policy had to be governed by that law. Thanks very much for watching. This is Dimitris Koulafetis. Don't forget to watch my other videos on my channel, my YouTube channel, and visit my website www.lawspec.info for further information.